Hi, everyone. This is Team 2, the Oversight Board. Today, we'll be discussing how we plan on streamlining content moderation and appeal processes online. As mentioned in the prompt itself, there is a lack of effective structures, especially for users to appeal against content moderation decisions taken by internet platforms. And this has had a disproportionate impact, especially on marginalized communities. When we talk about people of color, members of the LGBTQ plus community, or even specific communities such as the Rohingya community, there have been decisions taken without any kind of consultation from stakeholders. And this kind of reinforces the power dynamics on the internet, where the voiceless are left excluded and where internet platforms are taking the decisions to dictate what speech can be upheld or not. In addition to this, the algorithms that internet platforms deploy add to the polarization of internet platforms, creating really dangerous echo chambers and filter bubbles. And this kind of ecosystem adds to what we know as problematic content being proliferated across platforms. And towards this, why we want to create a new structure to decide on content moderation appeal cases is that these solutions have to come from a place of stakeholder, like from participatory processes involving stakeholders. And the entire concept of having such a participatory process can bring about diverse perspectives from these stakeholders, which is why we're proposing what we call a national content review board. Unlike the oversight board, which kind of fails to apply international human rights standards with very little remedial scope, and the transparency and stakeholder engagement is restricted. We want to bring about a lot more independence and global legitimacy to the NCRB. And similar to what the social media councils do, we want to bring the government to the table as well. And the NCRB will largely uphold these international human rights standards, as well as the Manila Principles and Santa Clara Principles. The idea, again, is to have a multi-stakeholder interdisciplinary approach to make content moderation a more democratic process. I'll pass it over to my colleague, Shubha, who's going to discuss the composition of the NCRB.
Shubha, you're on mute.
Thank you, Arpita. So about the composition of NCRB, we've tried to introduce almost every stakeholder we could think of to be a part of the board of NCRB. So from the state side, we'd like nominees from the ministries of Information and Technology, Law and Social Justice, Home Affairs, and Antitrust Ministry. Whereas from the corporates themselves, we'd like a representative each from the major internet platforms and also from the trade associations such as Technological Industry Council, etc. From the user side, we'd like civil society organizations to protect their own interests, pressure groups. Also, minority representatives from every faction of minority in a particular national domestic area will be very appreciated. Similarly, on the expert side, we'd like legal, technological, and trust and safety experts to guide us to make better decisions. NCRB should govern under several principles which make it more legitimate, more accessible, more predictable, more equitable, transparent, compatible towards rights such as UDHR, and make it a continuous learning process which makes NCRB's decisions ever growing and ever more acceptable. Now off to my colleague Neil for him to expand further.
Thanks, Shubha. So there are certain assumptions and caveats we want to state upfront, right? This is not an ideal model, and we understand that solutions in this domain will never be perfect. They're meant to be iterated and flexible. And so we'll start by piloting the NCRB model in a few jurisdictions that have the right to free speech, subject to obviously reasonable restrictions. We're very keen that legislation should be the basis of the formation of the NCRB, because that's what the key to legitimacy is. And that also implies a multi-stakeholder approach in which the governments are participatory and willing. And finally, we've outlined the cost of the NCRB, both administrative as well as the honorariums paid to experts and other associative costs, to be borne by the key stakeholders, industry associations, the internet platforms, and the government. Could we move to the next slide? We believe the model addresses several pain points in the system. The first being that its decisions, by virtue of being ratified by the government as well as the internet platforms in a particular local context, are binding, and therefore overcome several of the constraints that processes like SMCs or the oversight board currently have. The decisions pronounced by the NCRB also have non-binding effects, since they set precedents that help online platforms further define their community guidelines and refine the algorithms such that they work well in those particular contexts and by standards established by the NCRBs. Finally, we believe that a multi-stakeholder approach necessitates skin in the game from all the stakeholders. So internet platforms want to move towards some model of self-regulation that avoids authoritarian regulation and rules that don't let them function as the autonomous platforms they've been for so long. So they will be more invested in this. Governments that are participating in the NCRB model pioneer groundbreaking content moderation policies, the like of which the rest of the world will look to emulate. Non-governmental organizations and civil society organizations can advocate for user rights and data protection from within the room rather than being voices from outside, and that minority representatives find a seat at the table as well, and their points of view are heard. The functions and the responsibilities of the NCRB have been laid out, but I think the two key things that I want to highlight is that there will be spaces in which we will require experts to advise the board on specific issues. As Shubha already mentioned, there will be legal, technological, and trust and safety experts, but we also might need specific content experts depending on the nature of the content, depending on the user, depending on which minority groups are aggrieved or have posted this content. And so those experts will be called upon by the board when needed. All the findings of the NCRB will be released into the public domain, and this is super important so that the process is seen as transparent. Though we want to make sure that conflicts of interest don't come into place, which is why we're making a slight aside about the honorariums as opposed to revenue. Finally, the rules of the NCRB are based on a basic minimum threshold that we hope will be brought on from the Universal Declaration of Human Rights that all countries in the world have ratified to some extent, and that empower basic freedom of speech and expression. We want to make sure that users and internet platforms understand that free speech is a universal right, but it's not absolute, and that certain parameters need to be upheld to ensure that everyone can exercise their rights. And finally, we want to underscore that the jurisdiction of the NCRBs is regional because local context is super important, and the cases that NCRBs will take up will depend on the user jurisdiction. In many cases, we realize that geographical boundaries are blurred depending on where the user originates and where the aggrieved parties are. And so we have built-in mechanisms such that NCRBs can talk to each other across jurisdictions and that external and international experts can be called upon if needed. Finally, I'll hand it off to Anuradha to close this out.
Thanks, Neil. So the NCRB has to, because of the caseload that the NCRB is going to be receiving, the NCRB has to focus on categorizing and prioritizing cases. The focus of these of the cases that they take should be with both high impact as well as good outreach. But this does not mean that the NCRB should reject cases that are lower risk. It is also important that the NCRB try to figure out a balance between the impact of a post as regard to the content of the post, and sort of go on this, making these decisions on a case-by-case basis. It's also important for us to talk about reducing caseload while looking at prioritizing caseloads. And one way we want to try and ensure that this happens is to provide advance notice prior to any content getting taken down. Basically, we want to explain to the content creators which community guidelines have been violated and why, and give them sufficient time to either change their post or understand where an error has occurred, to make sure that the problem is solved before it even goes to the level of content moderation. We think this would definitely reduce the number of posts that are taken down themselves. And as a result of that, it would also reduce the number of cases that are appealed to the NCRB. In case the appeal process does not work, we're also looking at trying to figure out a mechanism where the platform can either archive or downvote the content, such that the content is not going to be shareable, but only viewable. And certain search criteria will get the content on board, but people won't actually be able to change or share that content. Finally, we want this organization to be set up under the umbrella of the ITU, such that the ITU can sort of streamline and synchronize some of the basic principles and also keep the functioning of the NCRBs current. And we hope that this will help keep the NCRBs, will help get marginalized communities on to the table and ensure that their voices are heard, especially when it comes to a lot of their content that is taken down. Thank you.